And to understand what this Supreme Court order means for Waqf properties, I'm joined by a very special guest. Professor Dr. Faizan Mustafa is one of the country's leading legal scholars, also Vice Chancellor at Chanakya National Law University in Patna. Appreciate your joining us, Professor Mustafa. How do you interpret what the Supreme Court has done? They've stayed provisions of the Waqf Amendment Act 2025 that was passed by Parliament, but they've refused to stay the entire statute. Is this what can be described as a balanced approach by the Supreme Court? Freedom to practice your religion on one side, but at the same time conscious of potential misuse of the Waqf Act?
Rajdeep, thank you very much. It's not so. Those who expected that the entire law would be stayed don't know the judicial process. The provision in Article 13 of Indian Constitution says that if there is a law which contravenes fundamental rights, then that law, to the extent of contravention, shall be void. Accordingly, entire law is never held. I am not recalling any law which in its entirety was stayed. So it's some provisions of any law. This is called doctrine of severability, that the judges will sever the part of law which is consistent with the Constitution and fundamental rights with the one which is inconsistent. And it will be the one which is inconsistent or which contravenes fundamental rights that would be stayed. Now, in the opinion of Supreme Court judge bench led by CJI, only few provisions of this law prima facie, on the face of it, look problematic and they have been stayed. Now, this is not a judgment, it is an interim order. Neither upholding of rest of the provisions in any way can be celebrated, not staying of some provisions is to be celebrated, because the case is to be heard yet again on merit and a final judgment will come. So right now, with this observation of Supreme Court, the law, most provisions of this law would be implemented, except the few which have been identified by the Supreme Court. Rajdeep, you also said about practicing religion and a balancing. So my first response was about balancing, but about practicing religion, I think there is a problem in the interim order. In fact, it is hugely problematic. Rajdeep, the provision which they have upheld is talking about that you need to practice religion for 5 years. I think this was the most problematic part of this law. In fact, the law used the word that you need to profess Islam for 5 years. The Supreme Court judges say that you have to practice Islam for 5 years before you can make waqf of your property. My problem with this order of the Supreme Court and this observation of the Supreme Court is this. Are we going to do religious policing in this country? A moral policing of the kind we are familiar in theocratic countries like Iran. Whether I am a good Muslim and a practicing Muslim or a not practicing Muslim, that judgment is not to be passed by any state official. Now, just because I don't have a beard, I will not be said to be a practicing Muslim. If I don't keep fast, or I don't pray 5 times a day, or I don't pay zakat, I'm not going to be held good, Muslim or a practicing Muslim, and then denied to make waqf of my own property. Now, I understand that the provision is in the context of people who converted to Islam. As the law stands, Rajdeep, conversion is not prohibited in India. The BJP states, as many as about 9 or 10 of them, they only prohibit forced conversion. Now, forced conversion is illegal. But if somebody voluntarily converts to any religion, including Islam, whatever ownership of the property vests in him, that ownership right is not going to change because he changed his religion. Now, it is his property. How can we say that?
Sir, can I go get a clarification? Sir, can I go get a clarification?
Yeah, please
Can I go get a clarification? What the order says of the Supreme Court the Supreme Court says it stays the provision requiring proof of being a Muslim, practicing Muslim for 5 years until such time as rules are framed. So for now, that contentious provision that you will have to prove that you are a practicing Muslim for 5 years has been stayed until such time as the rules are framed.
So now if rules are framed tomorrow, there is no stay on this. My question is, how can even through framing of rules, you will pass a judgment on anybody's religiosity? What state has to do with the private decisions of people,
but at the same time, sir, I take your point. But sir, at the same, so you're saying once the rules are framed, we will know just how this actual law, could this law lead to religious policing? That's your concern.
Yeah.
But at the same time, the court also has stated the powers of the collector. There are one of the other fears was that a district collector will have arbitrary powers to decide whether a particular property is waqf or not. So there is some, that's why I said there's some element of give and take.
No, I take your point. In fact, the biggest victory for the petitioner, I would consider, is the one where the designated executive officer will no more be able to determine the title. The court has said it should be done either by a judicial officer or by a quasi-judicial officer, which means a Waqf tribunal. Now, that is a huge victory for the petitioner. But I'm not on the balancing. I'm saying where problem is. Now, one, I identified that this 5-year practicing rule, as and when government comes up with rules, will become operational, but it's a problematic provision in itself. And therefore, ideally, it should have been stayed. 2,
right,
this condition that non-Muslims will not be able to make waqf. Now, it is the property of a non-Muslim. Ownership rights are unlimited in terms of user, in terms of disposition. If it is my property, I can destroy it, I can burn it, I can do whatever I want with it. Now, how can a state dictate to me what I should do with my property? And therefore, this right of non-Muslims, I take the point which Supreme Court has written that this provision came in 2013 and it was not there in the 54 law and in the 1995 law. Maybe, but there are judgments of 1920s, 1930s, even Nagpur High Court judgment, from which Justice Gawai is very, very familiar, has given a judgment as late as 1956 after independence that a non-Muslim can also make a waqf. Because waqf is not only for mosque and madrasa. Waqf can be for a hospital, for a school, for the construction of a road, or for the construction of a dharmashala. So it is a principle of jurisprudence that if it is my property, I should not be in any way restricted in terms of what I will do with my property. And therefore, this provision is also problematic, but the court has not stated.
So net, you're saying that this entire debate over Article 26 and the freedom to practice religion and thereby decide what I want to do with my waqf property, that's still open for debate. That is not settled by this interim order in any manner. And there is potential, therefore, for misuse and discrimination that could still follow. Am I right? Principles of equity have still not been upheld. And therefore, one will have to await for the final order.
That's right. You are right. But what I am saying, look at Article 26. It gives right to every religious denomination or any section thereof. You would recall on your show I had said that accepting non-Muslims or admitting non-Muslims in the Waqf board should not be opposed because we believe in the diversity. And the diversity of the society should be reflected in all institutions. Nevertheless, the problem is in the article itself. Article 26 gives this right only to the religious denomination or any section thereof. It does not talk of diversity. There are other laws, Hindu endowment laws, which do not allow even Bauds, Jains and Sikhs who within the constitution under Article 25 are considered as Hindus, but not Hindus for the purposes of Hindu endowment laws. So even the non-stay on the limitation provision is problematic because the court is saying that it is applicable, to all properties. But the Hindu religious endowment property laws in Tamil Nadu, in Andhra Pradesh, in Telangana do not make limitation law applicable in respect of such properties. I would repeat what Rajdeep I said earlier, that this whole law is problematic because there was an opportunity to come up with a uniform civil code, and Waqf and religious properties could have been the first such issue on which for all religions we will have one law, uniform law. But we missed that opportunity.
I think you made that last point you made, that this is in a way you still believe a missed opportunity. This was an opportunity to perhaps push towards a uniform civil code where not just Waqf properties but the properties of all religious denominations was subject to similar legal provisions. Now we'll wait and see whether the Supreme Court does that in their final order. As I said, for now, both sides in a way are cherry picking specific specific aspects of the order to claim victory in a way. But Professor Mustafa, for shedding light on this important order passed by the Supreme Court today, I thank you very much.
Thank you, Rashdi.